6 months ago, a federal court in Manhattan told the California winery Peju that a 2004 decision from the Trademark Trial and Appeals Board that its mark was not registrable due to likelihood of confusion with a mark owned by an Italian winery wasn't just bad news, it was binding. The winery couldn't even argue facts to establish no likelihood of confusion at trial. The issue, the court said, had already been decided. The winery lost, and a judgment was entered against it. On June 8th, 2026, the Second Circuit Court of Appeals vacated that judgment. The court held that the TTAB's 20-year-old registration decision could not be used to preclude the winery's defense because the Trademark Trial and Appeal Board never actually looked at how either company's wine was sold, to whom, or in what markets. This is a case about a wine called LIANA and a wine called LIANO, a one-letter difference, but that's been litigated for over 2 decades. But it's really a case about something every trademark lawyer needs to understand. When does a TTAB ruling actually bind a federal court, and when doesn't it? I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and today I'm joined by my partner and frequent briefing contributor, Tara Sattler. We're going to walk through Peju Province Winery versus Cesari, the facts, the 20-year-old procedural history. That won't take us 20 years, I promise. And the Second Circuit's reasoning on collateral estoppel and what it means for any brand owner who has ever lost a fight at the Trademark Trial and Appeal Board and is wondering whether that loss is going to follow them in the federal court. We're going to talk about that on today's installment of The Briefing. Tara, welcome back to The Briefing.
Welcome. You know, I am a frequent contributor, but I don't think I've got 2 decades under my belt here.
I don't have 2 decades either of The Briefing. I may have 2 decades of law experience, though. All right, why don't we get into this?
So before we get into 2 decades of procedural history, let's start with what's actually being sold here, because this case has a very specific fact pattern that ends up mattering a lot.
Right, it does. Okay, so Peju Province Winery, it's a California producer. It's Napa Valley and Mendocino. One of their wines is called LIANA, and it's 100% orange muscat. So you've probably had that before as a dessert wine. And that particular wine is sourced from Mendocino grapes. And Peju sells that branded wine exclusively through its own wineries and at its own website. So you're not going to find it at grocery stores. You won't find it at Bevmo. You won't find it anywhere else.
Okay, so that's Peju. And on the other side, we've got Cesari.
Right, Cesari. Cesari S.R.L. They're an Italian wine producer. Their mark is LIANO, and it's registered for wine generally. And the wine comes from a very specific region in central Italy. It's a table wine, and it moves through the broader retail and online channels.
Okay, so we've got LIANA and LIANO, one letter.
One letter, exactly. And Cesari, they sued Peju for trademark infringement under the Lanham Act, alleging that consumers were likely to be confused between the two marks given that one-letter difference.
So what's Peju's defense? Because on paper, one letter apart sounds hard, like a hard argument to win.
Right. Yeah, it does, doesn't it? But Peju's proposition is that despite the similar spelling, these wines don't actually compete for the same buyer. Different categories, dessert wine versus table wine, different origin, California versus Italy. And for wine consumers in particular, origin and varietals are really how people actually distinguish what they're buying, right? I mean, we both drink wine, and I know that you will not, and I will not mistake a California Cabernet for a Moscato, dessert wine.
Yeah, I won't make that mistake.
Right. Right. But more critically, the different trade channels, right? Peju's wine isn't sold anywhere. It's only sold at the Peju winery and on Peju's websites. And Cesari's wine is sold in the broader retail categories. So there's really, Peju was arguing, there's no overlap in the markets in which the wines are sold.
Yeah, so the legal question is the classic Lanham Act likelihood of confusion fight, except it comes with 20 years of baggage attached because this isn't just Peju and Cesari's first time addressing whether these marks conflict.
Right. And that baggage is the whole case. So why don't we walk through the baggage?
Okay, so it starts in January of 2003 when the USPTO grants Cesari's registration for LIANO for wines. Then 1 month later, in February 2023, Peju filed its own application to register LIANA for wines. Cesari sees that application and filed an opposition with the TTAB, and that's the USPTO's internal tribunal for exactly this kind of dispute. And the TTAB sides with Cesari.
Right. In July 2004, the board found the marks almost identical and likely to cause confusion. But here's the detail that ends up driving the entire Second Circuit's decision 22 years later. The TTAB made it clear it was deciding the case based only on the identification of the goods in Peju's application and the identification of the goods in Cesari's registration. Regardless of how the wine is actually sold, to whom it's actually sold, or through what channels the wines are actually sold.
Right. So why would the board ignore real world marketplace facts like that? Because that's how the TTAB registrability review works. The board is comparing the application as filed against the cited registration. It's not supposed to look outside for these four corners unless the application itself limits the goods. So Peju's application just said wine. There is no language about dessert wine, no language about California only or direct to consumer sales.
Right. Peju did raise that distinction, but it wasn't that it was specifically a dessert wine, that it was a California only and direct to consumer sales, but it was only in response to Cesari's opposition. It was not in the original application. And under the TTAB procedures, it was just too late. Really kind of what Peju probably should have done is suspended the proceeding, gone back and amended their application to put in these limitations, and maybe that would have had a better result under the TTAB. But they didn't do it. It was too late, so the board never reached the merits of the dessert wine or California only or direct-to-consumer sales only arguments at all. It simply wasn't part of the record that the board considered itself bound to.
So Peju loses the registration fight in 2004. And then more than a decade of nothing, at least in terms of litigation. And Cesari files a trademark infringement action against Peju in the Southern District of New York. And this is the move that matters. So Cesari goes to the district court and asks for a partial summary judgment, arguing that Peju is collaterally estopped, precluded from relitigating the likelihood of confusion because the TTAB already decided the question back in 2004.
Procedurally, very, very smart move on behalf of Cesari's attorneys here. And the district court agrees. The court holds that the 2004 TTAB decision settled the likelihood of confusion issue once and for all, and Peju was barred from arguing otherwise. So from there, the case goes to a bench trial on damages, and the district court enters judgment for Cesari.
So Peju loses at the TTAB in 2004, and that loss by itself ends up deciding the infringement case more than 20 years later.
Right. That's exactly what happened. And I can only imagine the lawyers representing Peju in the litigation, their minds must have been blown. So that's what happened until Peju appealed to the Second Circuit. And the Second Circuit answer is where this case becomes really important for anybody engaged in the trademark work.
Right. So let's frame the legal question precisely, because I think that a lot of listeners' instinct is going to be the TTAB and a federal court are both asking, is there a likelihood of confusion? Same question, same standard. So why wouldn't the first answer bind the second?
Right. That's precisely the question the Second Circuit had to resolve. And the doctrine governing it is called issue preclusion, so collateral estoppel. The basic rule is that an issue can't be relitigated if it was actually litigated and necessarily decided in a prior proceeding. Issue preclusion bars a successive litigation when, one, the issues in both proceedings are identical, two, the issues in a prior proceeding was actually litigated and actually decided, three, there was a full and fair opportunity for litigation in the prior proceeding, and four, the issues previously litigated were necessary to support a valid and final judgment on the merits. So the wrinkle here is that the TTAB and the federal courts, they don't use identical tests to determine likelihood of confusion. As you know, Tara, every single federal circuit has a different multi-factor test for determining likelihood of confusion. So different multi-factor balancing tests here between the Second Circuit and the TTAB, same general inquiry.
And that issue is exactly what the Supreme Court addressed in B&B Hardware versus Hargis Industries in 2015. The court held that a TTAB likelihood of confusion decision can have a preclusive effect in a later infringement suit, even though the TTAB and the district court don't apply identical factor tests, so long as the TTAB uses the same likelihood of confusion standard in substance.
Right, right. In that case, the Supreme Court said, so long as the other ordinary elements of issue preclusion are met, when the usage adjudicated by the TTAB are materially the same as those before the district court, issue preclusion should apply. So the district court here read B&B Hardware as, quote, like same standard, therefore preclusion applies. However, that reading was wrong because B&B Hardware really didn't stop there. The Supreme Court was explicit that ordinary preclusion principles still apply. And one of those principles is that the issues actually decided have to be the same issues presented in the second case. The court specifically flagged that the TTAB didn't consider the parties' marketplace usage. Its decision should have no later preclusive effect in a suit where actual marketplace usage is the central issue.
And that's not a new idea for the Second Circuit specifically. This circuit has been saying essentially the same thing since the 1990s in numerous cases.
So putting this all together, the rule the Second Circuit states is explicitly this. A TTAB likelihood of confusion determination has preclusive effect in a later Lanham Act infringement claim only if the TTAB's assessment took into account in a meaningful way the context of the marketplace.
Okay, so applying that standard to the 2004 TTAB decision here, it fails that test.
Right. It fails on the TTAB's own language. The board expressly said that it was deciding the case regardless of what the record may reveal as to the particular nature of the applicant's goods. That's not an ambiguous record the court had to interpret. That's the TTAB telling everybody in 2004 exactly what it was not considering. It was not considering marketplace factors. And remember, the TTAB never even reached Peju's dessert wine argument on the merits because Peju raised it procedurally too late. So there's no finding anywhere in that TTAB decision about dessert wines, nothing about direct-to-consumer sales, nothing about California-only distribution. None of it was litigated, necessarily decided.
Right. So let's talk about where the district court's reasoning breaks down. The district court's theory was that because the TTAB decided likelihood of confusion for wine broadly, it necessarily also decided the issue for every reasonable subset of that category, including Peju-specific dessert wine single-channel usage. The Second Circuit rejected that as an overreach. The court said you can't treat a finding about the broad category as automatically resolving a much narrower factual scenario the TTAB never actually examined. The court pointed to its own precedent. Banfi Products versus Kendall Jackson, where two similarly named red wines sold at different price points through different channels weren't found likely to cause confusion. Trade channel and market segment do real legal work in this analysis, and the TTAB simply never did that work.
Right. On appeal, Cesari argued that B&B Hardware effectively overruled a separate line of cases that the Supreme Court's 2015 decision definitively rejected that standard. The Second Circuit didn't just disagree, it found the two entirely consistent. The panel walked through B&B Hardware's own language, carving out cases where the TTAB didn't consider marketplace usage, and noted that the legal treatise, the leading treatise on trademark use, McCarthy on Trademarks, which the Supreme Court itself cited 10 times in B&B Hardware, described these cases as standing for essentially the same proposition the Supreme Court adopted. So this wasn't really a close call for the panel. Cesari's reading required treating B&B Hardware as having silently overruled circuit precedent that the Supreme Court's own opinion is consistent with.
Okay, so the bottom line, the TTAB's 2004 ruling and the district court's infringement analysis were never deciding the same issue.
Right, that's the holding, because the factual basis wasn't the same. Collateral estoppel was never available, and the Second Circuit ended up vacating the judgment and remanding it to the district court. So on remand, the district court is going to actually have to do the work that it skipped, the full analysis on likelihood of confusion that accounts for a real world picture. Dessert wine versus table wine, California versus Italy, direct to consumer versus normal retail channels. Okay, so let's talk about what this means. The district court's initial decision that a TTAB's determination of likelihood of confusion would have a preclusive effect was always concerning. I remember that decision when it happened, and it was concerning. In the context of likelihood of confusion, a trademark examiner and the TTAB generally analyze the conflicting marks, the goods, and the channels of trade only to the extent they're set forth in the application and the opposer's registration, regardless what the actual usage is by either parties. Essentially, the TTAB doesn't consider the true reality and any nuances that may be material in determining likelihood of confusion. In trademark litigation, real world factors, they actually matter. And the manner in which the parties use the marks, they're considered, whether they appear within the application or registration or not.
Yeah, so the question is, when would a TTAB decision cause issue preclusion? Based on the appeals court holding, it seems that courts are back to where they should be, the Supreme Court's guidance in B&B Hardware. In order for a TTAB decision on likelihood of confusion to have a preclusive effect, the TTAB and the district court have to consider the same elements.
I agree. And because of the context in which the TTAB decides likelihood of confusion, so basically limited to the four corners of the challenged application and the registration, I'm going to say it seems questionable whether a TTAB decision on likelihood of confusion could ever have preclusive effect. I mean, I'm going to assume that it is possible, but the probability seems very, very low.
Yeah, I agree with you, Scott. And so for Peju and Cesari specifically, this isn't over.
Right, not at all. As I said, it goes back to the Southern District of New York for the full likelihood of confusion analysis. The case really should have gotten in the first instance. And we'll be watching to see how the district court handles the marketplace evidence on remand. And if it's interesting, we might do another episode on this. All right. Well, thanks again to my co-host, Tara. Always great to have your insights. And thank you, our listeners, for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave us a comment or a review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.